I'm so pleased to welcome Macarena Montes Franceschini. I have seen Maca speak. She was at Vermont Law and she spoke to one of my animal law classes and have known her socially. But just want to give a quick intro and then I'll give it away to Maca. So Maca is an assistant professor at the Faculty of Law, Universidad de las Americas in Santiago, Chile. She holds a PhD in law from the Universitat Pompeu Fabra in Barcelona, Spain, and an LLM from Harvard Law School. From February 2023 to August 2025, she was a visiting fellow at the Brooks McCormick Jr. Animal Law and Policy Program at Harvard Law School. And she's also been a visiting researcher at the Max Planck Institute for Comparative Public Law and International Law in Heidelberg. She is a board member of the UPF Center for Animal Ethics, editor of Law, Ethics, and Philosophy, serves on the editorial boards of the Animal Ethics Review and the Chilean Journal of Animal Law, and is the treasurer of the Grade 8 Project Spain. She's also the author of Animal Law in Chile and several articles on animal personhood, animal rights, and the rights of nature. And that is going to be the topic that Maka will be discussing with us today. So I'm super excited to introduce Maka, and thanks so much for joining us.
Thank you, Vanessa. Hi, everyone. I'm really happy to be here today. Let me share my screen. Um, okay, present. Okay, can you see my screen well? Yes?
Yes.
Okay. Okay, so I'm gonna go quickly today because we don't have a long time. I'm going to be talking about the different types of cases in Latin America to try to advance animal rights in the region. And this has been part of my research for the last years. So I kind of have certain categories of cases. So the thing is that we're running out of time everywhere around the world. We're eating more animals. There's less and less wild animals now, less habitat. And so we need different strategies to try to advance things and protect animals in more effective ways. So, Latin America is the region around the world where there are more cases regarding animal rights. And what do I mean by cases? These are cases where a judge has recognized the animal as a subject of rights, or as a rights holder, or as a non-human person. I'm not talking about animal welfare cases or cruelty cases unless they have this component of considering the animal as a subject of rights. So as you can see on this map, most cases have been brought in Latin America, and most of the successful cases have been in this region. And if we add on the new novelty of bringing rights of nature cases and passing rights of nature laws, we can also find most of these examples in the region. So, first, these are the different types of cases. First, some cases were just brought symbolically, and it's interesting to talk about such cases because sometimes the metaphor of animal captivity is used to refer to violations of human rights. Then there are habeas corpus cases that were brought inspired by the work of the Non-Human Rights Project. There are other cases that are constitutional actions or remedies brought in different countries. There are criminal law cases, but where the animal is referred to as a rights holder, and also some criminal law cases where the animal is considered as a member of the family. And then there are rights of nature cases and more examples of animals being brought into environmental rights. So quickly, the first case I could trace in Latin America was a case in 1972 in Brazil. It was a habeas corpus brought on behalf of all caged birds in the country. It reached the Supreme Court, but it was actually a metaphor to protest against the dictatorship that exists in the country at that time. But it's interesting to see how people were already thinking about animals in captivity as something that is morally and legally wrong, and that the habeas corpus could be used in such a way. Then habeas corpus cases, several have been brought in Latin America. It started out with chimpanzee cases, as I mentioned, inspired by the Non-Human Rights Project's work. And of these cases, there's one successful habeas that was brought on behalf of chimp Cecilia, who you can see in the picture. She lived alone in a zoo in a concrete cage where her only enrichment was a forest painted on the back of her cage. Um, she was alone for decades, and a judge, a lower court judge, recognized her as a non-human person and a subject of rights, and ordered her transfer to a sanctuary in Brazil 6 months later. So she was quickly transferred, and the judge used several arguments to recognize her as a non-human person and a subject of rights. She talked about her sentience, her cognitive and social abilities. The judge also talked about environmental arguments. Um, and this is a picture of Cecilia's first night when she arrived at the sanctuary. This is the first time she was feeling grass under her feet. And this is a picture of Cecilia in the zoo when she was completely alone. You could see the forest painted on the back of the cage. And then this is Cecilia now at the sanctuary. Now she lives with a small group. She is friends with a chimp called Marcelino and another one called Miguel, and they will never be separated. This sanctuary is part of it believes in the principles of the Great Ape Project. So they treat their residents as non-human persons, and it's not a zoo, it's not a place to go look at the animals, or no, it's a sanctuary where the animals, they try to give them the best lives they can. Then there are several cases in Latin America where constitutional actions or remedies have been used for animals. So the most famous case is Sandra. This is Sandra the orangutan. She actually currently lives in the US in Florida. A lower court judge recognized her as a non-human person and a subject of rights. And the judge ended up picking a sanctuary in Florida where Sandra could live. This case started off as habeas, but then the attorneys filed an amparo, which is a constitutional remedy that seeks to protect other fundamental rights, like the right to life, to bodily integrity, to liberty. And so Sandra became famous because she was the first non-human animal to be recognized as a non-human person. And so there were a lot of cases. I mean, sorry, media published this story in Spanish-speaking countries and English-speaking countries, and well, she's very famous. Um, the interesting thing about the Latin American cases, such as Sandra's and Cecilia's, is that they have been cited as precedent in different countries and even inside Argentina. Even though the legal system isn't based on precedent, other judges use these cases to argue for other animals and expand this case law. So that is really important because judges usually, when it comes to animals, they do not want to be the first. They are worried, they're scared about expanding animal rights. And so you can see in Latin America and in other global South countries that these cases are cited and used as a starting point to argue for other cases. So, for example, Sandra and Cecilia's case were cited by a judge in the Margasar Zoo case in Pakistan, where also animals were recognized as subjects of rights and transferred to sanctuaries. And you can find this citation of cases all over Latin America. Then we have criminal law cases, kind of slash family law cases, because judges sometimes refer to animals in cruelty cases as members of the family. So this is Polly. Sorry, this is Tita. There are cases in Argentina regarding dogs that were mistreated, and in this case, Polly was shot dead by a police officer. The judge in the cruelty case, the judge said that Tita was a family member and a non-human person, and even it was really impressive because the judge referred to Tita as the non-human daughter of the human man that was involved in the was bringing the private criminal action. And so he referred to the dog as a non-human daughter and the father as the human father of the dog. And so it's interesting to see how cruelty cases, when it comes to companion animals, judges in Latin America aren't are I don't know, they don't have a hard time in recognizing them as family members. So now rights of nature cases. I'll spend more time here because this is becoming really popular in Latin America and in other regions in the global south. So we're going to talk about Ecuador because Ecuador is the only country in the world that recognizes rights of nature in its constitution. Um, where is this coming from? So Ecuador did not always have rights of nature in its constitution. It was added in the constitution in 2008. Before that, they had a constitution that recognized the right to live in a healthy environment. But as in other Latin American countries, the economic system is based on extractivism. And in the 90s, there was a huge scandal because Chevron Texaco dumped billions of gallons of toxic waste in the Amazon after extracting oil. And so there was a lot of protests against this, and indigenous peoples in the country were very well organized. And at the same time, civil society started to oppose extractivism when they saw what was happening in the Amazon. And at the same time, the government was giving priority to oil and mining as part of economic development in the country. So I'll show you some pictures of what extractivism involves in Ecuador. So this is it says Women for Life, Haku, which in Quechua means advancing together. It says the Confederation of Indigenous Nationalities resists. It says Up with Life, Down with Oil, and it says No DAPL, which refers to the Dakota pipeline in the U.S. and it's kind of supporting indigenous peoples in the US that are also protesting against extractivism in their territories. So this is Amazonian women, defenders of the rainforest against extractivism. And now let's see some pictures of what the oiling industry involves in the Amazon to understand a little bit better where rights of nature is coming from. So you need to cut down a big chunk of the forest to install an oiling facility. And you need to, there's a lot of deforestation going on. This is near the Yasuní National Park in Ecuador that is being defended by indigenous peoples. It's indigenous territory. At the same time, it involves building roads. There's always flares on, there's pipes, and there's a lot of construction that needs to be built. And also, there's even like airports that are being built in the Amazon. These are pictures of the pipes going through the rainforest. Pipes and the oiling industry and mining industry bring in illegal settlements. So people that shouldn't be living in the Amazon move in, and this brings a lot of conflicts. There's a lot of drug dealing, weapon dealing, a lot of wildlife trafficking, and there's a lot of conflicts between indigenous peoples that live there and new settlements. And there's also a lot of indigenous peoples in the Amazon still that do not want to be contacted. They want to be left alone and do not want to have anything to do with the rest of the world. And so it's a very complicated situation. And as you can imagine, there's a lot of danger in oil spills. And so there's non-human and human victims. This is a Guarani leader, Nemonte Nkimo, who wrote a book that you can buy in the US. It's called, I think, We Are Jaguars. And she talks about extractivism and growing up in an indigenous community in the Amazon. And the other picture, you can see frogs covered in oil. And then in the lower picture, you can see how dangerous it is to extract oil and how easy it is for spills to happen and for animals and indigenous peoples and riverine communities to be impacted by such an industry. So that context leads us to this is the important article on rights of nature in the Constitution in Ecuador. It says nature, Pachamama, where life is reproduced and occurs, has the right to integral respect for its existence and for the maintenance and regeneration of its life cycle, structure, functions, and evolutionary processes. And in the second paragraph, it's interesting because it says all persons, communities, peoples, and nations can call upon public authorities to enforce the rights of nature. So there's very broad standing, which is a really amazing tool to bring such cases to constitutional courts to try to protect nature and animals. So, how do we get from that article in the Constitution to animals? So you can imagine in 2008, a new constitution, and suddenly there's a new subject of rights. You know, judges in Ecuador had been used to humans being the center of the law, and suddenly you have nature. And so at the beginning, judges were like, yeah, we don't really know what to do with this. So they kept like linking the protection of nature to human needs. So it took them a couple of years to understand that what the Constitution was saying is that nature itself has a right, and it's independent from what human interest might be. Obviously, that this has to be balanced. And so the court started recognizing that nature has a right to restoration. So not only a human community that is impacted by pollution has a right to be restored and compensated, but nature itself too. So the court kept this case law, and eventually in 2021, Judge Ramiro Avila, in a concurrence, criticized the court for just acknowledging that nature, like this abstract entity, is a subject of rights. And this judge said, no, if we're saying nature is a subject of rights, that means that the elements of nature are subjects of rights too. And this was really important because this opened the door for animals. So after this case, the court considered that mangroves in the country were subjects of rights. Then after that, a very famous case called Los Cedros. It's a cloud forest, and so it was a very specific ecosystem, and what this forest was recognized as a subject of rights. And then came the woolly monkey case, Estrellita, where animals were recognized as subjects of rights. So, what's the deal in Ecuador with animals? Ecuador is one of the countries in the world with a lot of biodiversity. It's one of the countries that has a chunk of the Amazon rainforest. So there's a lot of illegal wildlife trafficking. Most of these animals are taken by very impoverished people in the country that are paid a couple of, I don't know, $80, $20, $50 to hunt animals. And then these animals are taken abroad, mostly to the US and Europe. For they're being kept as pet, private collectors, etc. So in this picture, you can see capuchin monkeys on the left that have been confiscated from wildlife trafficking. The monkey at the bottom is sedated because they were removing the chain. This monkey was kept as a pet for many years. And the little monkey on the left is a woolly monkey like Estrellita. And this monkey is probably the same age Estrellita was when she was poached. And to poach baby monkeys, you have to kill the mothers. So you shoot the mothers in the forest. The mothers will never abandon babies, and so they fall, and that's where they take the babies. So Estrellita's case, that little monkey that we just saw, Estrellita was probably around that age. We don't really know how, but she ended up living with humans for 18 years. Someone tipped off the environmental authority, and so they came and confiscated her because she was living in a city in an apartment. And the thing is that the authority didn't really think much about what they were gonna do with her, so they just stuck her in a zoo, and then she died less than a month later. And before the human family found out that she had died, they filed a habeas corpus on her behalf, requesting Estrellita's return and the court to issue a license so they could keep her. But as you can imagine, the lower court and the Court of Appeals dismissed this habeas corpus because they said, on the one hand, they said habeas corpus is only for humans. And second, they said it's illegal in the country for individuals to keep wildlife. So we can't issue you a license to keep Estrellita. Like it's impossible. That's illegal. The interesting thing is that the constitutional court in the country can choose and select the cases that the court wants to see. And it's interesting here because the court was coming from very successful, high-profile cases like Los Cedros and the Mangrove case. And so the court, like the easiest thing the court could have done is ignore this case and say, like, no, let's not get involved with a case on a dead monkey. We don't have to get into that. But it seems that the court was ready to say something about animals. And so the court wanted to answer these questions. Are animals subjects of rights? Is the writ of habeas corpus appropriate to protect animals? And if animals can be protected by the rights of nature. So at that time in 2021, I was doing my PhD in Barcelona, and I was hired by Harvard Law School, the Brooks McCormick Jr. Animal Law and Policy Program, to co-author the amicus brief that answered these questions. And we worked with Professor Kristen Stilt, with Stephen Wise and Kevin Schneider from the Non-Human Rights Project. And we answered, yes, animals are subjects of rights. The habeas can be appropriate for animals, and animals are subjects of rights protected by the rights of nature. And why did we want to do this? Because we wanted to create a tool in Ecuador for activists to be able to protect animals with a constitutional remedy. Constitutional remedies usually are fast, and you can reach the constitutional court and you get to talk about rights. And so we said, yes, individual animals are protected by the rights of nature because species are made up by individuals, and at the end, a species is like an abstract, and what happens to the individual impacts the species or the population we're talking about. And then we told the court that if they said no, they would have to answer then how many animals have to die to trigger the rights of nature. And as you can imagine, that's an impossible question to answer. So this was a very successful case because the court used all our arguments to say that yes, individual animals are protected by the rights of nature, so animals have constitutional rights. And the court said the habeas could be appropriate depending on the circumstances of the case, but in this case it wasn't because the monkey Estrellita had died. And then the 7 judges voted in favor and 2 against. But as you can imagine, not everything is perfect in the world of the law and the world of judges, because judges are always worried about the slippery slope. And you can see that in the US cases as well, as such as Happy's case. So the court felt that it needed to say that when a predator kills its prey, it's not violating the rights of nature. And I mean, this makes sense if we're talking about, I don't know, a cougar eating a monkey, for example, hunting in the rainforest. But the court used that argument to say that humans are predators and omnivorous. So, in the article that we wrote with Professor Kristen Stilt that you guys can look for, there's a very detailed explanation where we talk about how actually we think that the rights of nature and the principles behind rights of nature give a lot of arguments against industrial animal agriculture. And we think that the court walked a very fine line where it says we cannot prohibit eating animals, which makes sense because, well, then we spoke to the judge that wrote this case, and at the end, behind these cases, there's politics going on where judges need to get votes from the other judges and support each other. And so this case was kind of this slippery slope. Part of it is kind of a way to calm people because people would have jumped on what's going to happen with industrial animal agriculture and eating animals and all that. So in Ecuador, there's been positive effects of this ruling. There's been other cases, and there are more and more cases in Latin America that are uniting rights of nature and animal rights, or bringing them together. And an interesting case is in Panama. In 2022, Panama passed a bill recognizing the rights of nature. And in 2023, it passed a bill on the conservation of marine turtles. And when you start reading this bill, it sounds very conservation and not very rights focused. But it's interesting because it's linking the human right to a healthy environment with animal protection. And when you reach Article 29, it says that turtles have the right to have a free passage in a healthy environment. So this is the first time a law is recognizing that an animal has a right to a healthy environment. And so now you can see that the human right to a healthy environment in several countries around the world, especially in the global south, is being used in a way to get to animals and the protection of nature by seeing that there can't be a healthy environment for humans if there's not a healthy environment for nature itself and for animals, that there's this interconnection. And so then the most recent interesting thing that's happened in international law is that the Inter-American Court of Human Rights, in its latest advisory opinion on climate change, it recognized the rights of nature. And so now we can see that there's a regional court, a regional international court using the rights of nature. And this, like looking back to Estrellita's case and what's happening at the domestic level, it may give us a little pathway to expand animal rights at a regional level or an international level, also maybe through the rights of nature. And you may be wondering, okay, this sounds great. The US, this will never happen in the US. And yeah, probably Latin America is a very special place. There's a lot of biodiversity, a lot of a relationship between people and the natural environment, and indigenous peoples are very organized, among other things. But the US does have some states that recognize the right to a healthy environment in their state constitution. So perhaps this is another way to advance these topics forward in different places. So thank you, and I hope I took up all the time. I'm sorry. Thank you, Vanessa.